In the light of the fact that the applicant does not dispute most of the facts set out in paragraph 7 of my statement, I am of the opinion that on the undisputed facts, there was not the kind of relationship between myself and the applicant such as would disqualify me from chairing this commission, nor is it a proper ground for me to recuse myself. In any event, I am of the opinion that if the applicant was of the opinion that I should not chair this commission when the Chief Justice gave him my name, he should have raised the matter with the Chief Justice. The view he expresses that he would have been seen to be interfering with the selection of the judge to chair the commission is not sound. If the Chief Justice had given him the name of a judge about whom he, that is the applicant, had reports of corruption which he was planning to pass on to the Chief Justice, would he have kept quiet? I do not think so. After all, the Chief Justice would not have been bound by the applicant's opinion. He would have applied his mind to the disclosure and either stood by the name of the judge he had chosen or selected another judge. In my view, there was no sound reason why the applicant there is no sound reason why the applicant only raised the issue of a personal relationship between myself and himself close to 3 years after my appointment to chair this commission. The applicant cannot be allowed to raise this issue so late in the day. The applicant also contended that the manner in which the commission called its witnesses at the beginning gave rise to a reasonable apprehension of bias, because many of them appeared to be persons who had an axe to grind against him. In this regard, he referred to some of the ministers who testified before this commission. There is no merit on this point. The commission was free to use whatever witnesses were available as long as in the end the applicant was himself afforded a fair opportunity to come before the commission and deal with whatever evidence such witnesses may have given. The applicant also contended that after he had come before the commission and testified last year, the commission ignored the matters that he had raised during his evidence. The fact of the matter is that the applicant had not completed his evidence when he left the commission in July 2019. It was agreed that he would come back to continue his evidence. Since then, it is now more than a year, and the commission has been trying to get the applicant to come back to the commission to continue his evidence. Excuse me. But the applicant has had to be compelled by way of a summons to appear before the commission. Indeed, the commission has served the applicant with 2 directives in terms of Regulation 10.6 of its regulations, compelling him to furnish the commission with affidavits, but the applicant has not complied with these directives. Indeed, the applicant has to date not furnished the commission with affidavits he undertook in July last year he would provide to the commission. In these circumstances, it cannot lie in the applicant's mouth to say the commission has ignored the matters he raised in his evidence. Counsel for the applicant contended that I made various comments when certain witnesses gave evidence which suggested that I thought that the applicant was guilty of state capture. I've read all the comments quoted in the founding affidavit. I do not propose to refer to any one of them. I'm satisfied that the applicant's contention has no merit. As Mr. Pretorius SC submitted, I am entitled and sometimes actually obliged to ask witnesses questions and to seek clarification on their evidence because the Commission seeks to establish the truth on the matters that it is investigating. Even a judge in a court of law is entitled to ask questions and seek clarifications in a trial. The main difference between the applicant's approach to the comments I make and my approach, indeed Mr. Pretoria's approach, is that the applicant appears to expect me to be very passive when witnesses give evidence. I do not agree. I believe that provided I keep an open mind and act fairly, there is no difficulty in me seeking clarification from witnesses and testing their evidence. What is important is to strike the right balance. I am of the view that that balance has been correctly struck in regard to most, if not all, the comments about which the applicant complains. In the end, I conclude, having had regard to all the points that have been raised by the applicant, including the points relating to press statements and media conferences that he has referred to in his affidavit, I conclude that the applicant has failed to meet the test for a reasonable apprehension of bias. Accordingly, I conclude that the application for my recusal falls to be dismissed, and it is accordingly dismissed.